What's up, guys? Brian Fellow Law Group PLLC here with your Florida Law Weekly case update. Hope everybody's having a wonderful Juneteenth. It's been a while since I've done one of these, so it's great to be back with you guys. This week we got 3 cases. Let's get right to it. First case is Salazar versus Blanco. This is out of the 3rd DCA, and this is a case where the trial court did not adopt the parenting plan proposed by either party. I think they were both pro se. They both submitted proposed parenting plans. The court said, no, thank you. I'm not going to adopt either one of those. And what the court did was just enter a standard 50-50 equal time sharing schedule. But there was no reference at all that the court made any inquiry or any evaluation of the factors in 61.13. And even though the court doesn't have to explicitly put in the final judgment findings of each factor in section 61.13, there still has to be some sort of indication that the court actually considered those factors. So in this case, there really wasn't any indication that the court even considered any of those factors and just sort of made a standard 50-50 equal time sharing schedule. So that got reversed. The other thing that got reversed was the trial court ordered the mother to pay retroactive child support to the father during the period where the mother had full custody of the child. So that obviously didn't make any sense. I don't know why the trial court did that, but that got reversed as well. Next case is Lawler versus Lawler. This is again out of the 3rd DCA. This is a petition for relocation and a temporary relocation. So what happened in this case was, looks like these parties are in the military, or at least one of them is, the husband, former husband. And so basically, the former husband, they live down in the Keys. And so the former wife petitioned to relocate up to Jacksonville. And that petition actually got denied. And the court basically said there was no evidence to support, in favor of either party, and sort of maintain the status quo instead, where the children were living with the father in his blended new family down in the Keys. So then what happens? Well, the father apparently gets restationed up to South Carolina. And so the mom files basically like a motion to prevent or to extend her time sharing. She got time sharing during the summer. So she wanted to continue to have the kids live with her because the father was going to get restationed up to South Carolina. Meanwhile, the father filed a petition to relocate and a motion for temporary relocation. Apparently, the mother did not respond timely to that petition to relocate, which you have to respond within 20 days. Otherwise, the relocation is going to be presumed to be granted and presumed to be in the children's best interest. So the mother didn't timely respond. The trial court entered an order allowing the temporary relocation without a hearing. So no hearing at all on this motion for temporary relocation. Mother appealed. The trial court affirmed, basically said, number one, the mom didn't timely object. But even if the court ruled solely on the fact that the mother did not timely object, there was still evidence in the record to show that the temporary relocation was in the best interest of the children. The other thing was, the mom was saying, oh, but his petition is legally insufficient because he didn't have a specific post-relocation time-sharing schedule. The statute requires that. And there is case law that says if you don't have that specific post-relocation temporary time-sharing schedule, then your petition could be legally insufficient and denied. Well, the court said no, because the father, although he didn't have like a specific new time-sharing schedule, he referenced the prior time-sharing schedule that was in place. And he said, basically, I want to maintain that same time-sharing schedule. And the court said that's enough. So, you don't necessarily have to have a very detailed, specific post-relocation time-sharing schedule. If you reference that you want to keep the same time-sharing schedule, apparently that would be sufficient. So this got affirmed on appeal. Last case is Lawler versus Gonzalez. Again, out of the 3rd DCA. We got a trifecta out of the 3rd. Hat trick. Go Panthers. So this is a domestic violence case, and this reaffirms the fact that you don't really need anything more than one party's testimony to get a temporary injunction for domestic violence, or a final injunction for protection against domestic violence. So this was apparently like a classic he said, she said. And the mother, basically all she did, or the petitioner, I don't know if she's a mom, but the petitioner, all she did was really just testify and verify the allegations in her petition. Apparently she didn't present more testimony or anything like that. Just, she basically said verbally what she put in the petition. The father or the respondent denied those allegations and said, that's not enough. He said, she said. Well, the appellate court said, well, I guess that really is enough. If the trial court hears testimony from both sides, grants an injunction in favor of the petitioner, that means that the trial court found that the petitioner was more credible. And that's a determination that the trial court can make. And so, you're not going to be successful on appeal if all you argue is, hey, I said I didn't do it, she said I did it. Not good enough. Apparently in this case, the petitioner said that the guy pointed a BB gun, shot a BB gun at her, and threatened to kill her and her family multiple times. And, even if there's no specific evidence of that, her testimony was enough to get that injunction for protection against domestic violence. All right, guys, that's it for this week. I hope everybody has a great week, a great Juneteenth, and I look forward to speaking with you guys again. Take care.